Welcome to Financial Fitness. I'm your host, Philip Board, along with
Mia Medina.
Let's dive into today's topic. I hope you enjoy it. Being in the financial services industry, we often recommend that our clients get trusts. And what we realize is a lot of people don't do it because they don't understand the terminology. So what I think we should do is, how about you ask me some of the questions that people don't understand, and I'll see if I can answer them and demystify it a little bit so that they have a better understanding of why they should or should not have a trust or powers of attorney or will or something like that. Does that sound like a conversation we can have?
Yeah, I think that's fair, because I do agree there's a lot of clients that it's very overwhelming to them. They want to create a trust, but then a lot of times they don't even know what to think about to start even implementing. So I think that's a good idea to kind of give everyone some background at least and basics.
All right. So I know quite often it's like, oh, I don't need a trust. I don't have enough assets. So to give a little background, as I go into, or we go into the nuances of the terminology, right? It's like, who should or should not have a trust, right? So generally, I personally go off of, look, if you own a house, you should get a trust, because sooner or later you're going to pass away and you want that to go to the people you care about, not through probate. And we'll discuss what probate is. It's expensive. Let's just say that. It's inconvenient for your heirs. So if you have a trust, oh, I don't own a home, but I have children. Well, that would be another reason to have a trust. Now, if you don't have a home and you don't have children, then perhaps powers of attorney and a will are sufficient.
Here's a good one for you, though, because I feel like I get asked a lot of this too, just from family members too. What's the difference between a will and a trust?
Okay. So a will is basically a written document that says, when I pass away, I want these people to receive my stuff, right? Generally, it's used for assets such as a house. It can be used for, maybe you got a collectible car or some family jewelry, heirlooms, or if you've got a bank account. A will is letting the people know that that's who they're going to get. Wills, however, have to go through probate. So let me guess, you've got another question. What is probate?
What is probate?
I knew you were going to ask that.
How to avoid probate.
So probate is the process of, if you don't have a trust. So this is, I know I'm answering many different questions at once here, because you asked what's the difference between a will and a trust, but it's leading to a will goes through probate. So probate is the process of a judge determining that the heirs you have specified are indeed the heirs that they should. And it's a public affair, meaning that you've got to hire an attorney who's going to essentially go to the judge. They're also going to publish, hey, Philip passed away. Does he owe you money? And it's put in the newspaper. It's sent out there. And on a seminar I've given or a workshop, I use the joke about, oh yeah, you get this neighbor come out of the woodwork that he loaned you a lawnmower 50 years ago, and now it's a classic and it's worth $1 million. Now it's up to a judge to determine A, if that happened, and B, if it's worth $1 million. And the reality is, I would avoid probate at all costs. Now, bank accounts, et cetera. Now, IRAs, though, are different because they have beneficiaries on them, which means they pass directly to the people that you have specified. So hope that helps with the probate. So what does a trust do? A trust is something that it's a much more private affair. So it's a document that's drawn up by a lawyer that inside it, there are several other documents, a pour-over will, there's a trust document, the powers of attorney, both financial and healthcare. And lawyers love to make things complicated. So a financial power of attorney is also called a durable power of attorney. So those documents are included in there. And a really good trust will now have something for your digital estate, which I think is important. And also a section where you can fill out saying, hey, you know what? I don't like worms. I want to be created. That's my wife right there. She's like, I don't like worms. I want to be created. I don't want to be buried. She's actually joked to me before that she goes, yeah, well, after I pass away, I want you to sprinkle some of my ashes on the top of a double diamond ski run. So that way I can say I actually skied one. So, but a good trust will do that. It's private. Nobody has to go to a judge to say, hey, we have this trust. What do we do? So, and I know you've seen this in our own business when we have clients come to us or their children, actually, when their children come to us and say, hey, mom and dad passed away, we have their trust. We can look at them and go, great, give us a death certificate. We can get the money in your hands in about 10 days to 2 weeks. It's going to be really simple and easy. But if they pass away without a trust, it's months. We have to turn them away and say, we can't help you. Because if you've got a brokerage account with a few $100,000 in it, then you've got to go through the court system and have a judge decide if you are indeed the rightful heir to that, which means our hands are tied for a period of months, which I don't think as financial advisors, that's not being helpful at all. So that's one of the reasons why I push for our clients to have a trust. So hopefully I've gone a roundabout way to help you understand why you need a trust over just a will.
Thank you. So another question that a lot of clients, I guess, have is, okay, I'm ready to, establish my trust. And then we ask them, who do you want, I guess, the beneficiaries to be? And then I feel like a lot of the times that's when they get a little confused. Like, what is a beneficiary? Who should I name?
Okay.
And who shouldn't I name?
Oh, okay. Not your dog. Let's start there. We need to be a living person, a human being. This day and age, you're going to be careful how you qualify that. But we're talking about a human. Beneficiaries are quite simple. It's the people you care about. Who would you like to receive the proceeds left over from your hard work after you pass away? Generally, as parents, that's a very short list. It's our children. That's who we want to have it. Now, we do run across a fair number of people that don't have children. That is where it gets complicated because they don't know who to list. So then it starts going, oh, I want to do my brother. I want to leave the money to my brother or sister. But then you realize they're all the same age. They're all 80 years old. So now you need to have backups. So in writing a beneficiary in the trust, there's a couple different ways to do it. So let's say let's talk about my own family. I have a sister, but she has no children, right? And if I had no children and I said, I'm going to leave it all to my sister, but then she passes away, there's no one to leave it to. It goes to whoever her estate is, which would be back on my side of the family. So it gets pretty interesting. You've got to look down the family. So it could be my sister's the primary beneficiary. However, if she predeceases me, then the proceeds of hers will go to, and maybe we pick the ASPCA, someone that's taking care of dogs, or maybe St. Jude's, or childhood cancer research, or breast cancer, or something like that.
Yeah, some sort of charity.
Yeah, and I think where people get stuck and not doing is because they don't know the answer to that question. And I can tell you, an answer is better than no answer.
You do not want it to go to probate.
Right. So, which brings me to some of the things that we've done with our own family. So I'm probably jumping ahead here, but
why don't you start with what a trustee is, maybe. We have the beneficiaries. We know that when we pass away, we want our assets to go to the beneficiaries. But then sometimes you got to choose a trustee or successor trustees. And then sometimes there's that confusion of should it be the same person?
All right. Well, the definition of a trustee, and I'm going to read this, is an individual or institution appointed to manage the assets placed in a trust according to the terms specified in the trust document. So essentially, it's when you create a trust. So when I created my trust with my wife, we were the original trustees. We still are because we're both alive. So we are the original trustees, right? But our successor trustees are people that if we pass away, and my children are, or our children, excuse me, are still minors at the time of this recording, so they cannot be successor trustees because they're minors. They're not the age of majority. And even then, just to being 18 doesn't make them good custodians. Because I know if I inherited a lot of money at 18, I might not have seen 19, right?
A lot of money, sometimes that's involved.
Yeah, there is some serious money involved. When you think about the value of your house, your retirement accounts, value of a business, there's maybe life insurance, there's a lot involved. So for us, we actually chose some, actually you're one of our trustees. So Mia is actually, since we've known each other for so long, and being that, doing what you do for a living, you make sense to be a successor trustee because I know that you, A, you know where the money is, and B, you know what you're doing, right? But some of you might choose maybe a brother or a sister-in-law or a close family friend or something like that. But you basically want an adult that you trust with money. Now, for those of you that have adult children, in having this conversation, you've probably already identified that one of your children is really good with money and can follow details really well. And I think that's the case for most people. So a successor trustee is someone in your circle who you have a great deal of faith in to carry out the letter of the document that you've drafted, in this case, the trust. Who gets what, when?
Then as far as like a grantor, I know a grantor is usually the one who establishes a trust. Therefore, the trustee is not always the grantor in, I guess, trusts that been established for a while.
Okay, so
right?
What is a grantor
Yeah.
is the question, right? And this is something that you, if you read a trust document, that's one of the first words that comes up, and it goes right over everybody's head. So a grantor, essentially, when my wife and I made the trust, we were the grantors. Because you look at a trust as, for lack of better terminology, its own entity, right? So if you just draft a document and you don't put anything in it, it's just a document. So how do you put something in it? Well, as a grantor, I changed the titling of my house from my wife and I's name to the name of the trust. We grant that asset to the trust, right? So the grantor. Now, there are certain kinds of trusts where you might be setting up something for a special needs child, right? In that case, I could grant assets to that trust, but somebody else could be the trustee for it. So whoever's giving the item to the trust is the grantor. In personal estate planning, generally, it's the trust makers or the grantors, and they're also the primary trustees of the trust.
Thank you.
No problem.
How about an executor? There's
Oh,
a
boy.
lot of terminology in a trust.
There are. So an executor, and this is where, I got to paraphrase this. I'm not a lawyer. I know an awful lot about trust because we advise our clients on it. And this is why I'm having this conversation, not a lawyer, because I'm trying to not make it complicated, right? But from my understanding, an executor is someone who, after you pass away, on a will, is an executor. Now, the person that executes your trust after you pass away is the successor trustee, right? So they're synonymous terms, but an executor is generally someone who's in charge of an estate of someone that only had a will or no will. Sometimes that's court appointed, which you don't want at all. So yeah, they're the person appointed to administer the decedent's estate, the person who passed away, the deceased estate. And basically their job is to make sure that the rules are followed.
Thank you. Now, a lot of trusts include powers of attorney, or at least they should include as part of the trust. What would be the difference between a power of attorney and the healthcare directive?
Okay, so they're both powers of attorney. However, where we see people, we get this all the time. Oh, I went to the hospital, I had some surgery, I filled out a directive. That's generally used for the event, that surgery. And it's just a stopgap to make sure that if you end up coming out of the surgery unconscious, that they have someone that they can go talk to, right? When it comes to a trust, there are two powers of attorney. One is your healthcare power of attorney. And in there are all the things that someone can and cannot do for you. Like, for instance, if you're getting on in age a little bit and you don't want any heroic measures, meaning you don't want a feeding tube if you're brain dead, and just your body kept alive even if you're not there. So that's one of the things a healthcare directive can do. They can unplug you, essentially. Generally what it's used for is if, let's say, there's a complication in surgery and you are unable to make a decision, that you've empowered someone to make that decision for you. Usually it's someone close to you that has hopefully a decent bedside manner and a decent grip on what it is that you want to have happen in the event of you being unable to make medical decisions for yourself. They're also used for dementia, memory loss, right? Unfortunately, my mom is going through a bit of that right now. And I think we're really close to having my dad execute the healthcare power of attorney on her because she's getting very, very forgetful. But that document will allow my dad to interact with the doctors and help find a course of care for her as she continues to age, right? So that's the healthcare. Now, another power of attorney is durable, or in lay terms, the financial power of attorney. What that one allows you to do is if, let's say you end up, I don't know, you're unconscious for a while. You're in an induced coma for a few months. Well, somebody needs to pay your bills. Somebody needs to make sure that whatever money is coming in is, maybe you've still got a mortgage on your house or a car payment or something that you are expecting to make a full recovery from. Somebody needs to take care of making sure that that continues to happen. Now, the unique thing about powers of attorney, and this is where we see a lot of confusion, is after people die, they say, but I have a power of attorney. That power of attorney ceases to function in any capacity at the moment of death. So they no longer work at that point. So powers of attorney are used for health and finances while the individual maker of that power of attorney is alive. Now, what's interesting about healthcare and financial is financial, you can have two people and you can make them act together or one at a time in succession. When it comes to healthcare, only one at a time. So you can't choose both my children at the same time. You have to choose this child first, this child second. Whereas with the money, you can say they've got to both agree. So some nuances.
Can you choose the same child to be on the healthcare and on the financial side to be the same person?
You can. However, in my own family, my sister lives much closer to my parents, so she is their healthcare power of attorney in the number one seat. I am number two. In the financial side, I am number one, given what I do for a living, and she is number two. So you don't have to have the same people in order. And you could use different trustees than power of attorney. So if you've got 3 or 4 children, you could have two children be the trustees of the trust after you've passed away, but then you could have two others be the healthcare and the durable. Personally, I think that gets a little complicated because generally what we see is whoever is the power of attorney for the durable, the financial, ends up being the successor trustee on the trust, just because it's the same mindset. Because trusts are about ultimately who gets the assets, the money, not so much the health care, because that's all over at that point.
One last question. A living trust. A lot of the times the title of the trust would say, the Medina Living Trust.
Uh-huh.
How's that different than what maybe other people might see as when it becomes a revocable living trust?
Oh, so the difference between a revocable and irrevocable trust. So the trust that I would encourage most of our clients to get, the original trust, would be a revocable living trust. What that means is that you can change it. And this is, I think, where a lot of people get confused. They think that once they make the trust, that's it. No, it's a living document because you get to change it. Hey, one of your kids ticks you off, they're out. I'm not saying you want to do that, but you could do that. You can change it. Or maybe marries into a family and there's other things always change, births, deaths, and you want to add grandchildren or remove people. That's what a living trust can do. So that's revocable. That's what I have for my family. And that's what you have as well. An irrevocable trust would be something that happens after death. So generally revocable living trusts while you're alive become irrevocable at death. And instead of having a social security number, they would have a tax ID, right? So now you can't change them after death. Another type of irrevocable, I'm saying that slowly because people get the two confused. Irrevocable trust would be an intentionally defective grantor trust, which that's a type of trust that is used for particular kinds of estate planning. Perhaps you have more than $20 million and you want to make sure that you carve $10 million outside your estate while the estate exclusion amount is really high. You can do that with using an irrevocable trust because now it's over there and it's outside your estate. Or perhaps if you've got a child that is special needs, when you pass away, that money goes into that trust so that they're entitled to the income from it, but they won't ever receive the money if it's going to kick them out of a group home or the benefits that they're receiving or what have you. So different kinds of trusts, but generally most people need a revocable living trust. I'm going to add, we did have a client that said, this is not what you said it is, because it didn't say it in the title. And it took me a while to figure out what he was talking about. But ours just says the Board Family Trust. That's all it says. It's a revocable living trust. In this case, we were doing an intentionally defective grantor trust, but it didn't say irrevocable or intentionally defective in the title. It was his name. So understand that just the titling is different. So one more thing on titling too. Another way to look at this, and an attorney told me this, I thought it was pretty genius. You can, let's say you started your trust. I'm on my 4th rendition of my trust. Because when I first got married, it was just my wife and I. Then we were going to adopt children. We adopted one child, then we adopted a second child. So each time we've amended it, right? So a trust, and it's still the Board Living Trust. Think of it this way. If you own a house and it's got an address, you can knock down the house and rebuild the house, but the address is still the same. So that's what a living trust can do. You can change it as often as you like. And a lot of attorneys now offer a program where they'll do an amendment for a nominal fee rather than having to restate the whole thing.
So how often should you amend the trust?
That's a great question. And the correct answer to that for me is when the tax law changes. Now, for instance, we see some trusts sometimes that are 20 years old. Well, 20 years ago, they had something called an A-B trust, right? what that meant is upon the first passing of the first spouse, the money was carved into an irrevocable trust for half. On the other half, the surviving spouse had access to. But when those were about, the estate exclusion amount, the amount that you could pass to your heirs without estate tax, was like $675,000, a tiny amount of money in comparison. It felt like a lot at the time, but now it's $23 million. There's no need for us to do that. So the newer trusts are no longer AB trusts. They're just straight trusts. So if you've got a trust that's older than about 5 or 6 years old, I would consider at least getting a review and seeing if that language is in there, because we've run into cases where there's lawsuits because the trust was never administered. So it wasn't split into two. And then mom remarried and the kids over here are now out of the estate and they're suing mom's estate because they should have had their share of dad's half. And instead it's all gone over here. So yeah, that's a concern, especially when there's remarriage, which happens a lot. Thank you for joining us today on Financial Fitness with myself, Philip Ward.
And Mia Medina.
I hope you enjoyed today's topic. If you want to know more about our conversation today, feel free to reach out to us, oneononefinancial.com or oneonone-eldercare.com. Both places, depending on what you want to know. We're more than happy to help you out. Look forward to seeing you on the next episode.